Thank you, Rachel, and welcome to everybody that's joined so far, and thanks for being here today. My name's Cameron McCue. I'm an attorney here at Holland & Hart in our Boise office. I work with our healthcare and litigation practice groups, and I'm really excited to talk with you all today about this topic that I think is on the mind of a lot of us in a lot of industries, and particularly in the healthcare industry. And just so you know, this presentation is being recorded and it will be available on our YouTube page after. I've got a lot to cover in 30 minutes, and so we're not going to take questions during the presentation, but if you do have questions, my contact information will be at the end of this presentation, and you can feel free to give me a call or shoot me an email, and I'd be happy to speak with you. Otherwise, you can also, I think, put questions in the chat, and Rachel can collect those and get those to me. Let me get this going. Here we go. Just quick disclaimer, this isn't formal legal advice. This is for general information purposes, and I'm going to speak at a fairly high level given the time that we have, just so I can hit the key points that I think are on a lot of people's minds. But of course, in individual circumstances, consult with your legal counsel and your IT people to assess your own specific situation. Before we really dive in, I just kind of want to talk about how we got here. And artificial intelligence, and I'm no tech expert. I like to think that I've got a fairly good handle on it, but my understanding is that artificial intelligence has actually been around for quite a while now, but before the last couple of years, it was mostly operating in the background. And at least in my mind, it was back around 2022 when really artificial intelligence, as I see it in these, generative AI chatbots, really came onto the scene, and it just absolutely exploded. I mean, I was working for a judge at the time, and I remember he came in and said that he saw some news story on the Today Show about how ChatGPT was able to pass the bar exam, and I thought that was just incredible, and I didn't believe him. But sure enough, now here we are years later, and it's everywhere in healthcare and the legal industry and beyond. And specifically in the healthcare industry, the AMA does a physician survey, and this one's from quite recent, and it reported that now 81% of physicians are using AI. And it's not just, for small isolated use cases, they're using it for all sorts of things. And the thing that comes up, and perhaps this isn't surprising, is that the number one concern from providers in the use of AI and the rise of AI is patient privacy. And I think that is a warranted concern. This data, I think, is also interesting in looking at how Americans view the rise of AI, from the range of, do they see it as having a potential positive impact or a negative impact? And healthcare and medical care is at least one area where Americans see AI as possibly having a great benefit. And I tend to think so as well. I think it's a really useful tool. I think that there's a lot of things that AI can streamline and improve as far as improving patient care, improving, provider burnout, streamlining administrative tasks that take up a lot of time. And I think that there's, the world of potential benefits we don't even really know yet. But I do think that as we embrace this technology, we of course have to be cognizant of the risks and how it fits into the current legal frameworks that we operate under. And today specifically, I'm going to focus on just a small sliver of AI. And I'm going to talk about AI and HIPAA and PHI in those specific use contexts. But there's all sorts of other topics that I won't cover today, but providers should also be thinking about. I mean, there's ethics and professional responsibility considerations, standard of care. How do we inform patients and get informed consent about the use of AI in treatment? And how should we be transparent with patients? How do we deal with hallucinations, and bias in these models, how it fits into licensure frameworks. All of those things are really important, but are part of a broader discussion that we'll continue to provide resources here at Holland and Hart on those things, and be consulting with your legal counsel and thinking about those issues as well. But specific to HIPAA and patient privacy, this matters a lot right now because perhaps I think in a lot of the studies I've seen, the biggest uses of AI are for things like drafting clinical notes or improving those, streamlining those administrative tasks that providers are going through. They're using it to summarize patient records and referrals and compose portal messages. And in doing all of that, I mean, it implicates this risk of protected health information leaving the provider's environment and entering private vendors like OpenAI or Google or Microsoft, entering their servers and giving them access to data that is protected under federal law. And if it's not treated correctly, can expose providers to a wide range of serious consequences with the federal government and beyond. And I'm not going to get into the nitty-gritty of every definition of HIPAA here, but I think that the main concepts are thinking about, okay, who does HIPAA apply to? HIPAA applies to covered entities, which health plans, clearinghouses, and providers who, as the regulation states, transmit health information in electronic form in connection with a standard transaction. I think maybe the easiest way to think about that is if you process electronic insurance claims, you're likely going to be a covered entity. That's not to say that all providers are covered entities. If you're a cash-only pay practice and you don't process any of those standard transactions, this stuff, at least from the HIPAA perspective, might not apply to you. But it's important first to get an understanding of your practice model and be aware of, okay, am I actually covered by HIPAA? Probably, but in some cases not. And of course, the core concern of HIPAA is patient-protected health information, and that's patient information that's individually identifiable to the patient that relates to their past, present, future healthcare payment. And the other core aspect of this that we'll be talking a lot about today are business associates, the outside vendors and third parties that covered entities, healthcare providers partner with to help them do their day-to-day services and care and treatment, payment and operations functions. And then the other core tenet, I think, of HIPAA is thinking about what the risks are. And if you are a covered entity and you're handling PHI, the risks are pretty substantial, very substantial. I mean, there's civil monetary penalties that are in the tens of thousands of dollars. You could find yourself in a highly burdensome corrective action plan with the federal government. Of course, reputational harm. If you have to notify patients that their protected data has been accessed in a way that's not authorized by the law, that's not a great look. And if you're knowingly misusing it, you could wind up in prison, which is not great. Now, the most basic sort of permitted disclosures under PHI, which I'm sure a lot of you are familiar with, are the TPO, or treatment, payment, and operations. And these are disclosures and uses that providers make on a daily basis that you don't have to go back to the patient for their individual authorization every time you use or disclose PHI for one of these purposes. Treatment, that's obviously a big one when you're providing or coordinating or managing a patient's care, or working with other covered entities for the treatment of a specific patient that they also have a relationship with. When you're making those sorts of disclosures and uses in the ordinary course, you don't, for most types of care, don't need to get an individual authorization from the patient. And the same goes for payment, and then also healthcare operations, things that you're doing internally to run your organization and continue providing patient care. Now, there are some exceptions to this. One of those are psychotherapy notes, which is a specifically defined category of PHI under HIPAA that even for treatment purposes, unless it's your own treatment purpose, if you're gonna, consult with another provider, you have to get specific patient authorization in those circumstances. Now, providers obviously, in many cases, don't do all that they do on their own. Oftentimes, there are third-party vendors that you need to bring in to, help you manage your business and help you provide care and do billing and operations purposes. And that's a category of third party that under HIPAA is called a business associate. And that too is specifically defined. These are those persons or entities that create, receive, maintain, or transmit PHI on behalf of the covered entity. And so the regulations include specific examples of the types of common functions that business associates perform, ranging from data analysis, claims processing, etc. And pertinent to today's topic, a business associate can include AI vendors who are providing these chatbots or services to providers to help them perform those treatment and payment and operations purposes with their patient data. Now, not every third party is a business associate. If you're working with them and they're not receiving any protected health information, if they're only receiving data that's been properly de-identified under HIPAA, which there are specific rules for that I'll just touch on briefly later, they're not a business associate, and you might want to avoid entering unnecessary contractual agreements or business associate agreements with those vendors. There's also this conduit exception, which in the AI context doesn't quite apply. The idea here is that if there's an internet service provider or some third party that really only has like an incidental brief, pass with PHI, it's not something that's storing data. It's something that's, think of it like, the pipes that the PHI is flowing through. Those two wouldn't constitute a business associate. And what HIPAA contemplates is with these third-party business associates that are helping providers create, receive, maintain, and manage PHI, that's fine, but the federal regulations require that the covered entity providers get satisfactory assurances that their business associate is going to appropriately safeguard the PHI like the covered entity would, keeping it in-house. And that satisfactory assurance is essentially the business associate agreement that I'm sure a lot of you are familiar with and have with lots of other vendors. And so I won't keep belaboring that point, but the thing I do think is important to think about with business associates, even if you have an agreement in place, is the business associate can't use or disclose PHI in a manner that would violate HIPAA if the covered entity would have done it. And I think importantly for AI use, which I'll get into here in a second, when you're disclosing information to your business associate, the minimum necessary standard applies. That not for treatment disclosures, but if you think about it, in the context of using ChatGPT or whatever it is, and let's say you have a valid business associate agreement with whatever vendor it is that's providing that chatbot, you probably still wouldn't want to upload 500 pages of a patient chart to help you with whatever function is that you're using the chatbot for. And just because you have a business associate agreement in place doesn't create new categories of permitted use. If the disclosure would require patient authorization, if the covered entity were going to make the disclosure, then it's still required before the covered entity could share it with a business associate. There are certain categories of data that are, require heightened caution or that have additional restrictions under the regulations. I touched on psychotherapy notes earlier. Substance abuse records under CFR Part 2 are generally stricter than HIPAA. And then thinking in a broader sense, some states have even stricter laws than HIPAA for certain types of data. And under the statutory scheme, you always need to comply with the most restrictive law, which in some cases might be state law rather than federal HIPAA regulations. Now, again, I mean, I touched on this already. Obviously, HIPAA is a big deal. You all know that. You want to make sure you're complying with it, because if you're not, the risks are severe and they're broad and they can have a really adverse impact on your practice. So now, having the core background foundation out of the way, I want to talk about what I'm sure you're all more interested in hearing today is about how does this all work in AI, chatbots, and generative AI as we're currently thinking about it. And I think when we're using these models, if you're just stepping back and thinking about it at a high level, you want to think about, okay, is the PHI leaving my control? Am I putting this into some software that is going out into the ether to OpenAI, through ChatGPT, to Google, through Gemini? And if it is, I need to think about, okay, what is the purpose of me putting this in this chatbot? Does this fall under one of those exceptions like treatment, payment, or operations that allow you to make that disclosure without getting the patient's authorization? And if it does fit into one of those, do you have a business associate agreement with this vendor that allows you to make that disclosure so that you have satisfactory assurances that the vendor is going to protect the data under HIPAA just like you would if you were keeping it in-house? And I mean, this can be implicated in all sorts of AI uses that are increasingly common. That survey data that I pointed to earlier, at least 86% of physicians are using AI on a daily basis. And what I find really interesting here is we have access to these models and these chatbots across such a wide variety of devices and software, and in your browser, on your phone, and physicians. This is from that same study. They're at the same time as using AI in their professional capacity, and this doesn't just apply to physicians. I mean, this applies to really anybody in the healthcare space. At the same time, we're starting to use these programs for our personal life to help us manage the grocery list, to help us do all to research, to do what all the various things that AI can do for us. But what that means here in this HIPAA perspective is you really have to think about, okay, what is the context in which I'm actually using this chatbot? I mean, what is the space in which I'm using this? Am I using this in an environment that is actually protected by a business associate agreement where the data is going to be protected? Or have I, knowingly or not, opened it on my phone, which isn't logged into my work account and is just a consumer account? Am I putting in PHI into a program that is giving OpenAI or any of these vendors exceedingly broad range to do with the data what they want? And the good news is a lot of the major chat bot companies that are the most popular, at least that I've seen, they do offer these programs. So it is available. Obviously, in a lot of these you have to pay for it, and it's quite expensive. But that, by going through those companies' business tier or enterprise versions of the model, you are protecting your data. But you need to be careful, because you might, again, be using, let's say, Copilot on your work computer that's protected. It's got a business associate agreement in place. You're using the minimum necessary. And from a HIPAA perspective, that's fine. If you are in the clinic and you pull your phone out and you open up Google, which now seemingly by default puts data into Gemini and runs a chatbot version of your inquiry, have you inadvertently or not now put PHI into an environment that's not protected? So you really need to be cognizant of that as you're using these models, and it's getting increasingly more difficult, because I mean, like I said, it's like you probably shouldn't be Googling patient information anyway, but I mean, if you put something into a browser, you might even be on your work computer and put something into a browser, put it into a chat bot, and then now you've disclosed information without being protected by a business associate agreement. And so I thought it would be useful in the time we've got left to just kind of run through these practically and think about how, from a HIPAA perspective, we would analyze these issues. Now, for this one, let's assume this is ChatGPT, the consumer version. You go into the Apple App Store, you download ChatGPT, and you've got the program on your phone. And a provider quickly types out these notes and wants to ask, okay, what should I do next? So if you're thinking about it from a HIPAA perspective, let's say, okay, does this contain PHI? Yes. I mean, it's clearly got identifiable treatment information. It's got the patient's name, date of birth. It's clearly PHI. Is it being disclosed to a third party? Yes. When you hit send on that inquiry, that data is going to OpenAI, and under the default settings can be used to train their models, can be used to do all sorts of things. But what's important from the HIPAA perspective is not necessarily what they're doing with it once you send it, it's that the fact of you disclosing it to them. So if you think, okay, well, what's the purpose of this disclosure? Because HIPAA says, I don't necessarily need patient authorization for treatment or payment or operations. Yeah, this is probably a permissible purpose, whether it be, you could maybe see this as treatment or healthcare operations, depending on how you look at it. Okay, well, that might be fine, but is it a permitted disclosure if you're using it in this context on your personal phone without a business associate agreement? No, it's not. Because although you have a permissible purpose for the disclosure, it doesn't eliminate the need to have a business associate with that vendor. Now, how about this one? Okay, so I pull open that same program on my phone, but I go into the temporary chat feature. And to top it off, I go into my settings and I turn off improved model for everyone. Now it seems like, okay, well, this seems protected. I mean, it says right there, it's won't appear in history and it's not going to be used to update ChatGPT's memory. Does that change the analysis from a HIPAA perspective? No, it really doesn't, because even if temporary chat affects the data retention policy and how the vendor is going to use that data, what matters is that the PHI has left your control and been disclosed to a third party without the business associate agreement in place. The disclosure happens when you hit send. And so this doesn't really help you. Okay, by contrast, let's look at this example. So here, this isn't on your phone. Let's say this is on your work computer and you're, the hospital or the clinic or whatever environment has a enterprise subscription business associate agreement in place with Microsoft, with Copilot. You know that you're operating in that environment because you're signed in. It's got this little green shield right here, which pops up as an indicator that you're operating in the enterprise data protected environment. So let's walk through the analysis then. Does this involve PHI? Okay, we look at it. Yeah, obviously it's got all sorts of PHI in there. Is it being disclosed? Yes, it's the same thing. I mean, this is going to Microsoft. It's just like in the previous example, it's going to OpenAI. Okay, can we make this disclosure? Is there a proper purpose for it, or do I need patient authorization? No, you can probably make the disclosure without getting the patient's authorization. This seems pretty clearly like healthcare operations. It's asking for help with documentation support. Okay, so we've got a proper purpose. Is it permitted? Yeah, generally here, assuming it's within the scope of the BAA, this would be a safe and proper use of an AI chatbot in the healthcare context. Now, because this is a operations purpose, you still have to think about, the minimum necessary standard, make sure you're operating within your institution's policies. If you want to make sure and work with your IT people and, attend the trainings or have a good understanding of what exactly the organization's relationship is with the vendor. But, assuming all that checks out, this is good. Okay, well, how about here, where we type out a clinical note, we're wondering what we should do next after we see this 68-year-old male patient. But here, all right, well, we've taken the patient's name and date of birth out. They probably, that probably can't identify him from that. So does it contain PHI? The answer is probably yes, because even though this query doesn't directly identify the patient, there's still a reasonable basis to believe that the information could be used to identify the individual. There's enough there that taking those context clues together, I mean, a third party could identify them. And under HIPAA, de-identification has two very specific ways that needs to be done. One of those is through an expert determination, where you have a qualified expert, certify that the way this data has been de-identified, there's not a reasonable basis to believe it can be used to identify the individual. Or you have to remove not just name and date of birth, but 18 specific identifiers and have actual knowledge that there's still no re-identification risk. And I think this is a really interesting area here with the rise of AI that hasn't fully been explored yet, because we really, I mean, at least I don't have a great sense of, the capability of what these models are to take even data that would traditionally be viewed as de-identified, to take that and identify it. I mean, a lot of these chat models and accounts now have personal context, where, they're building a profile of the user to better serve their needs and understand their preferences. And if they've got this data in one place that matches up, they might be able to identify it. And so I think that's a developing area of the law that will be really interesting to see how it's addressed in the coming years if the federal government or state governments decide to wade into the world of AI regulation, which that's a whole other can of worms. This one I know, I did a version of this presentation for the Idaho Psychological Association a few weeks back, and this was one of the biggest questions that came up, perhaps unsurprisingly. And the question here is, okay, I've got an AI tool, that's great. I mean, you turn it on, you record, and I can talk to my patient, and we can go through the whole visit, and afterward, I click the button, and it generates this amazing chart note that takes the burden off of me of having to type it out and do all these things. I'm sure at least some of you have seen The Pit, and I've seen this episode, which I couldn't help but include here because it was so poignant. But thinking through the HIPAA analysis, does this involve PHI? Yeah, most likely. Purpose of it, treatment, healthcare operations. Is this permitted with a BAA? Probably, generally, yes. And I know these tools are coming to Epic and they're widely available and becoming more so in the healthcare space. But just some other things to be thinking about. And while these might not go directly to HIPAA, is what is your organization's policy on letting the patient know, or we're asking the patient for consent, and the accuracy of what the program generates after the conversation is, again, a whole other conversation, which is illustrated well in this issue, or in this episode of The Pit. But then you've also got to think about state law and recording, and that can vary. Idaho is a one-party consent state, and years ago there were regulations that bared on this question of patient consent and recording, and those have since gone through an overhaul and ultimately been repealed. And so, at least from a state law perspective, you might not necessarily need to get the patient's consent to do this, but that doesn't mean from other perspectives that you shouldn't at least notify them that you're going to do it. And if they request that you not record and use AI to record the visit, then best practice would be to not do so. And that's how Dr. Robbie feels about AI. Just one last example here. I know we're running short on time. Here we've got, this is a Gemini enterprise account. The provider has a business associate agreement with them. So we're in a good protected environment. We don't have patient authorization, but if you look at the note, revise into organized progress note, it sounds like a payment or treatment for a treatment or operations purpose, which is generally, you'd think, fine without patient authorization. But if you look at the content of the notes, yes, this does involve PHI, but it looks like psychotherapy notes, which, as I touched on earlier, are a specific category of PHI. It's leaving the practice okay. Again, it looks like we've got a permissible purpose to disclose this to Gemini, but here, because these are psychotherapy notes, this actually wouldn't be a permitted disclosure unless you had a separate specific patient authorization to use and disclose these psychotherapy notes in this manner, which touches on, again, having the BAA in place doesn't change the underlying rules of when you can make disclosures without patient authorization and when you can. And so just thinking through this analysis as you're using the different tools that are available to you across your devices are important for many reasons, avoiding risk. And I know it's difficult, and really we're operating under a regulatory framework here that is years older than these programs, which have just popped up in the last, in the grand scheme of things, just the last couple of years. And just in closing, some other things to think about with AI and HIPAA. If you're using AI to help you, draft charts and clinical notes and things, patients have a right to access their most of their medical records. There are some exceptions, and so that's going to be something that they see. So take that for what you will. If you want to make sure that if you're using AI and what's going in there, it's correct. And they also have a right to request that you not use AI to use their PHI, but under HIPAA, you don't have to agree if a patient requests restrictions. But if you do agree, you have to honor the restrictions. And then, they also have a right to request an amendment. So watch out for hallucinations, and that's another developing area of the law. So just in closing, thinking about this big picture, what should you do? Try to the best you can. Identify all the AI use cases and tools that you have in your organization. There are so many, but have a good understanding of which ones you have and which ones are worth using on a regular basis, so that you can prioritize, having the right agreements and protections in place for those programs. Make sure you have a good understanding of what your data is. When you're working with vendors, confirm and vet them and make sure that, there are so many of these now, startups that are advertising themselves as, healthcare compliant AI. Well, you definitely want to dig into what that means before you, enter an agreement with them or start using their program and putting the sensitive information in there. Make sure at a broader level, working with your IT folks that you have strong access controls and logging, making sure folks are trained on, what restrictions you have to keep this data safe and make sure you're being compliant with HIPAA. Make sure that providers know, what environments are safe, what aren't, reminders about minimum necessary, and, have policies on this. Do your due diligence, make sure you're getting patient authorizations when you need it, and planning for if and when things might go wrong. So that's the end of my 30 minutes. I know I sort of flew through there, but again, my name's Cameron McCue, and if you have any questions or follow up, I'd love to talk with you. We've got resources on our Holland and Hart healthcare blog page. I am shortly planning on publishing an article that touches on a lot of these issues that will hopefully serve as a helpful resource as you continue to navigate these fun and exciting times with AI. And I don't recommend relying solely on AI for HIPAA guidance because it isn't always correct. Well, thank you, and that's all I have.